Welcome to Inside Employment, a podcast series by Herbert Smith Freehills Kramer that explores the latest developments in Australian employment law and practice.
Welcome, listeners, to our new podcast, Inside Employment, the Australian Employment Relations podcast. I'm Drew Pearson, a partner here at Herbert Smith Freehills, and I'm joined today by Charles and Sophie. Welcome, Charles and Sophie. I'll introduce you, Charles. Charles joins us from Fragomen, a global immigration firm who supports corporations across a diverse range of industry sectors as well as individual clients. He leads the advisory and compliance practice group here in Australia and across the Asia Pacific region, and is based here in Sydney. Hi, Charles.
Hi, Drew. Thank you for having me.
And our regular listeners will know Sophie Beaman, an executive counsel with us here at HSF, also based in Sydney. We're very excited to bring this edition of the podcast to you today. We have seen over recent years similar ideas, mechanisms, policy positions emerging in relation to all manner of issues touching on individuals and in particular workers here in Australia. Talking with Charles recently, we saw that there were some real policy themes and also enforcement themes that we could see across the different regulators. And we know that both Australian regulators and international regulators are working closer and closer together. Before we get into those themes that we're seeing, Charles, what are you seeing as the top couple of issues in the immigration space in 2025?
Sure. Migration issues have been really top of mind for many employers, particularly those who are reliant on migrant workers to fill their critical skill shortages. And migration has also attracted significant media attention, being the topic of much political debate, where employer groups, unions, community organisations have been very much weighing in as well on the discourse. And this government in particular has been really focused on bringing a greater alignment between immigration and employment law. And we, of course, now have Tony Burke as the Minister for Home Affairs, who was previously the Minister for Employment and Workplace Relations, and was really responsible for driving a number of key reforms in that portfolio. So in terms of emerging themes that we're seeing for employers, definitely increased compliance and enforcement activity. This has been, again, a real focus of this government, which means that organisations really need to respond accordingly to ensure they have the right governance structure in place over their immigration program, so they're not putting their migrant workforce or their company's reputation at risk. And the increasing crossover between employment and immigration really means that if there's any issue that arises in respect of migrant workers, really both immigration and employment laws need to be carefully considered, just to ensure that potential risks are managed. Secondly is probably ongoing immigration changes. Again, looking at what this government's been doing since it's come into power, they've also been driving a number of reforms in the immigration space and as part of its migration strategy in particular. So we've just had some significant changes in the temporary and permanent employer-sponsored space in December, along with the introduction of a new national innovation visa. And it's really important that employers are keeping abreast of these changes. And lastly, the ongoing skill shortages and competition for talent. So a lot of employers are under pressure to find alternative solutions, again, with all the changes to attract and retain the right people. Last year, the government implemented quite a lot of flexibility for sponsored visa holders, which meant that they can more easily change sponsors and it doesn't necessarily impact permanent residents. So these sorts of changes really require employers to have a broader rethink of their immigration policies and how this fits into their sort of broader employee value proposition.
Great. Thanks, Charles. And I think in the employment space, we've certainly seen over the last decade that the Fair Work Ombudsman has really shifted its approach to enforcement and kind of becoming the cop on the beat, so to speak. Initially, the FWO was very much an educational approach that we were seeing. They'd partner with employers, come in, upskill employers and the industry more generally. Then in 2019, the then Fair Work Ombudsman wrote to many of the ASX listed companies, setting expectations and being very clear that they were moving into a new phase of enforcement activity. And we've certainly seen that activity occur since 2019. There's various significant payroll compliance issues that have come to light with organisations coming forward and self-reporting. What are you seeing on that kind of regulatory focus side of things in the immigration space?
A lot of similarities with what you've just outlined, Drew. So again, this government has been very much focused on immigration compliance and enforcement, something which we haven't seen for quite some time. They have also commenced with educational visits to employers, probably the latter half of last year. And from the beginning of this year, what we've seen is much more enforcement activity. So if I take a couple of examples, we've actually received a number of notices from the Australian Border Force, which is the enforcement arm of the Department of Home Affairs, where this is in response to perhaps what we would call administrative breaches of sponsorship obligations. So particular notifications that needed to be made to the authorities within a certain period of time were perhaps missed or put through late. Those sorts of breaches in the past we wouldn't have seen sort of any enforcement activity on, but just from the start of this year, we've started receiving some notices where the department has said, look, this is a breach, we want to understand, we're considering taking action against the sponsor, we want to understand how this happened, what are you doing to remediate and mitigate the risk of that reoccurring. So that's sort of been coupled with increased funding to the compliance and enforcement arm of the department, greater cooperation with Fair Work. I mean, there's been a long-standing sort of MOU between the Fair Work Ombudsman and ABF, the Australian Border Force, but really greater cooperation with Fair Work and other government agencies to be a bit more targeted and sophisticated in terms of their compliance initiatives, and a shift to employer compliance. So previously, the focus would have been more on individual visa holders and whether they're complying. Now the focus is very much on our employers doing the right thing. And the legislation we had come in middle of last year was actually titled the Strengthening Employer Compliance Act. So really the two main areas they're looking at is right to work compliance. So that's ensuring that all of your employees have the appropriate visa and work rights to be able to work for you. And not only the initial check, but the ongoing checks and tracking of visa expiries. And then sponsorship compliance. So any of your sponsored visa holders, you're meeting your obligations in terms of the occupation they're working in, the pay they're receiving, is that in line with market rates? Are you making the right notifications, keeping the right records, etc.? So lots of activity in that space, and really places a lot more responsibility on employers to ensure that they've got their house in order.
Great. And so if I might bring you into the conversation there, we've recently seen the FWA come out with their new policy positions. What are we expecting the shift to be from those?
That's right, Drew. I think the last time we were here, actually, we were talking about what we might expect in 2025. And one of those was an updated compliance and enforcement policy from the Fair Work Ombudsman. And we've got that at the start of this year. So last year we were doing some crystal ball gazing. I think I was saying I was hoping it might give some greater clarity in relation to when employers might be expected to self-report and potentially even remediation programs. We've got that clarity maybe in some areas, but also some additional questions. So there's two key things I think to flag in terms of changes that have been made to that policy. The first is that it now only applies to unintentional underpayments and to self-report in relation to those unintentional underpayments. And then the Fair Work Ombudsman has now released a new cooperation agreement guide, which relates to intentional underpayments and expectations in relation to those types of underpayments. The second key difference that I wanted to flag is that at least as the new policy is drafted, the expectation that previously was under the 2020 version of the policy for employers to self-report systemic underpayments to the FOA appears to have been dropped. So the word systemic has been removed, although whether an underpayment is systemic still remains relevant in the list of factors to the FOA in determining whether they are going to prosecute. So the compliance policy now encourages employers to self-report in relation to broader and or historical unintentional non-compliance. And there's still the guidance in the policy that existed in the previous version that isolated payroll errors which are identified of a period of up to 12 months aren't reportable provided they've been rectified and appropriate processes have been put in place to resolve those issues. So I think that change in drafting makes it a little less clear now, potentially, whether the FOA does expect that even cases of underpayments which aren't systemic, if they extend beyond that 12-month period, will be reported. So potentially a broader kind of category of underpayments that the FOA might expect, but remains to be seen. Other references in the policy still do emphasise that the FOA does have that kind of focus on what are systemic underpayments. Other changes in the policy that are worth noting is that it now refers to the FOA working constructively with other stakeholders to expand its reach and to optimise its approach to compliance. So I think picking up, Charles, on some of the similar themes you were talking about in terms of these regulators and other stakeholders working a little bit more cooperatively and in a more sophisticated fashion. So the previous version of the policy was largely silent on this, but this policy does expressly refer to key stakeholders. Similarly, the FOA now expects that voluntary self-reports will contain confirmation that employers have also notified relevant third parties, and they expressly refer to employer organisations and unions. Previously, the 2020 version only required confirmation that the ATO had been notified. The old 2020 version of the policy did reference the FOA referring matters outside of its statutory functions to other regulators, but now it expressly states that the FOA can conduct joint investigations with other regulators in relation to unlawful conduct that might be a breach of the Fair Work Act. And similarly states that the FOA has formal arrangements in place with the Commonwealth and state regulators with respect to information sharing. I think one of the ones that springs to mind, given the work we do with a lot of clients at the moment, is long service leave regulators and the extent to which we can expect the FOA is going to be sharing information and talking to those state regulators about LSL compliance. There's also now more detailed guidance in the policy on the FOA's approach to enforceable undertakings. So we've seen that due to a new provision in the Fair Work Act, which did actually require the policy to include that detail. So the policy now sets out the circumstances in which a enforceable undertaking will be entered into, or at least where the FOA is more likely to accept an EU. That includes where a person has a limited or no history of non-compliance, if they've admitted that they have committed contraventions of the Act and expressed some form of contrition, including a contrition payment, if they've fully cooperated with the FOA investigation process, they've meaningfully engaged with impacted parties and their representatives through that remediation process. They've agreed to pay interest on unpaid amounts, including superannuation, apologised, expressed contrition. So similarly to the terms that we would expect to see in an EU, if a party's willing to agree to those, we can expect that they will enter into one. The policy now states that you can expect that an EU will typically be around 2 to 3 years in length, so that the FOA can monitor and make sure that an organisation is committing to those new processes and systems to make sure it's achieving those cultural changes that are required. And it expressly states that even if an EU is entered into, third parties, so employees and unions, can still bring claims against an employer, notwithstanding that the FOA won't, which was obviously a right that already existed, but the FOA is being more express in relation to that. And then finally, in the policy, the FOA has now expressly called out that it reserves the right to make media statements, even during the term of an EU. So look, they're really, stressing their educational piece there. Again, I think picking up, Charles, on some of your similar comments. Lastly, I just wanted to mention, as I flagged up front, that they've also released this new cooperations agreement, which addresses its approach to the new criminal wage theft provisions that have been introduced, and the circumstances in which they'll enter into one of these cooperation agreements in relation to criminal wage theft.
Terrific. And then maybe if we switch gears slightly and look more to the themes. Charles, I was interested when we were discussing this recently, there's a growing space or a role for unions to play in the immigration framework. Can you let us in a little on that.
Sure, yeah. So unions have always had a role in what we call labour agreements. So labour agreements are a special arrangement that employers can enter into with the Department of Home Affairs to enable them to sponsor people in occupations that perhaps aren't sponsorable under the standard program or with certain concessions as to English, salary, etc. So in the labour agreement process, there is a requirement to consult with the relevant union that has coverage for the roles that are included in that labour agreement request. And usually what happens is that if the union does come back with any concerns, then those will need to be addressed, but more so with the department. So they don't have a right to veto the request, but it's more that any concerns they raise, the department will need to be satisfied that they've been addressed appropriately. The development we had was recently the government introduced a new type of industry labour agreement, this time for the aged care industry. Under that type of labour agreement, it's actually a precondition to entering into the labour agreement that there's a signed MOU with the relevant union. And the aged care provider, under the terms of that MOU, needs to agree to certain terms which are aimed at ensuring priority is given to local workers. So you can imagine that's presented, this sort of new role for unions has presented challenges for aged care providers who perhaps are already in negotiations with the union, for example, in relation to a new EBA. So which makes for sort of an interesting dynamic in the negotiations, where they're kind of, the challenge is that they need to agree to certain terms and perhaps in a less stronger negotiating position because they do need access to this particular labour agreement to attract and retain staff. Going forward, the government's also planning to introduce a new stream in the 482 visa, which is the main sponsored temporary visa, which is called the Essential Skills Stream. And this will really cater for sponsorship of workers in the care and service sectors where perhaps the salary is under the current threshold, but with additional protections. And it's envisaged that unions will also have a similar role under that stream, where they will need to be consulted, or there might be, for example, an MOU or similar agreement that they'll need to have signed with the relevant union before an employer can make use of that particular stream to sponsor workers.
Very interesting. And I guess, Sophie, we probably don't need to talk to the listeners about the expanded rights of unions under the closing the loopholes and other reforms that the government's brought through. But the second theme that I thought was interesting across both regimes was individual liability. Do you want to talk to what we're seeing in the employment space there?
So most recently, from the 1st of January this year, we've seen the new federal criminal wage theft commence, and that offence can implicate individuals personally. So that might be employees, officers, or agents of an employer. So individuals can be personally criminally liable if they commit what's referred to in the legislation as a related offence. And that could include, for example, where they assist an employer who has, to their knowledge, committed the criminal offence in order to enable that employer to escape punishment or to dispose of the proceeds of crime. It could include aiding, abetting, counselling, or procuring the commission of the wage theft offence by the employer. And that criminal offence is punishable on conviction with a fine and a term of imprisonment of not more than 10 years for individuals. The Fair Work Act, of course, includes an accessorial liability provision as well. And we saw some quite high-profile prosecutions by the FO last year where they prosecuted individuals in relation to those offences and penalties were imposed. So the two big ones that spring to mind is the DTF World Square proceedings, and the former general manager and former HR coordinator of that company were both found to be accessorially liable. And similarly, the Sushi Bay proceedings where the owner and sole director was found to be personally liable as well. So Charles, I think that's something that's been built into the immigration regime as well.
It's really interesting just when you sit down and start talking about there's so many parallels. So in the Migration Act, there are a number of provisions where actually executive officers can be held personally liable for certain breaches. And a good example is the right to work related breaches. So this is where executive officers, which is defined as directors, CEOs, CFOs, or company secretaries, may have criminal liability where they knew were reckless or negligent in terms of right to work compliance. They were in a position to influence the conduct of the organisation in regard to that, and they failed to take reasonable steps to prevent that from occurring. So the government has said that right to work compliance is a real focus for them. They've actually dedicated resources to ensuring that employers are on top of this. And in fact, the strengthening employer compliance legislation that I mentioned earlier actually increased the penalties for non-compliance for right to work breaches. And again, mirroring the Fair Work legislation, there are also accessorial liability provisions in the Migration Act, which do impose individual liability. There was a case, Chung Enterprises, some years ago now, where a HR professional was actually held liable for sponsorship breaches of sponsorship obligations by the company that she worked for, and that was under those sorts of provisions. So my expectation is there will be, with the additional sort of focus on compliance and enforcement, that there will be more appetite to actually prosecute against these provisions, and again, we'll see a much greater focus on this sort of compliance.
And picking up one of the points you made earlier around the preference for local labour over immigrant labour, we've seen a real shift or a real drive towards employment security being a key driver of reform in the employment space. I know that there's been some limitations placed on the use of fixed and maximum term contracts for employees. I understand there's similar movements in the immigration space as well.
Yes. So what we've seen with fixed term contracts is a lot of employers tend to use that mechanism. So having visa holders on a fixed term contract as to help them track visa expiries. And with this, and so often the contract expiry date will align with the visa expiry date. And what we've seen with these limitations coming in from a Fair Work perspective is that it's meant that employers have had to consider sort of permanent or open-ended contracts for visa holders. And this is where they've really needed to rethink how they're actually tracking or monitoring their temporary visa holders, including the visa expiry dates. So it's really meant that they have to look at their data integrity. So the employee data, are they actually accurately capturing the immigration status or the citizenship status of all of their employees? And often there's a really good process at the beginning of the employment relationship to check right to work, but the ongoing sort of checking, monitoring expiry dates, ensuring that visa conditions are adhered to sort of is a bit of a blind spot. So it's really important, I think, for organisations to be looking at that, looking at their HRIS, what sort of processes do they have in place to capture that employee data? Do they have any gaps in that? And what do they need to do to get it to a place where it's going to be useful for them to really support them in ensuring compliance?
And so it's probably a good point there just to flag those maximum term, fixed term employment limitations that have come in from an employment perspective.
Absolutely. So they were introduced as part of the Secure Jobs, Better Pay suite of reform. So they have been in place for a little while now. And I'm sure a lot of our listeners, will be familiar with them. But just as a bit of a recap, these rules are designed to restrict or to limit the use of maximum and fixed term contracts for a period of 2 years. And so that prevents either the hiring of employees on contracts with a term of greater than 2 years, but similarly the renewal or the extension of contracts beyond that initial 2-year period, or the engagement of employee on kind of multiple rolling fixed term contracts where they're doing the same or similar work. So it sounds like those contracts are driving a lot of the focus in the immigration space. And I think probably really similar issues for employers in the employment space in terms of making sure that they've got the right processes and systems to be, identifying where there are risks of fixed term contracts exceeding some of those limits. There are some exemptions to the restrictions as a reminder for the listeners. So the use of fixed term contracts is permitted which exceed the 2-year period for specific tasks, which include specialised skills. So I can imagine that that might be one of the exemptions which is relied on in the immigration space. Training arrangements where it's to fill temporary absences and things like that. So there are some areas where employers will be able to offer contracts which do exceed that period.
Excellent. Now, we're running close to time, but before I do bring us to a close, one last question for both of you. If you're a senior executive or a director on a board, what are the questions that you would be asking in respect of immigration and employment kind of generally? I don't know, Charles, maybe if you want to.
Really good question, Drew. Yeah, I think the 3 questions that I'd be asking, and there's probably a couple of sub-questions. Are we on top of our immigration compliance? So are we ready in the event of an audit or inspection? Do we have the right technology, systems and processes to support this? Second question would be, how do immigration changes impact on our workforce? So do we have an action plan in place to address these sorts of challenges? And thirdly is, what's our immigration strategy? So does this align with our internal policies and our overall organisational objectives? Really taking time to sit down and work through sort of the key areas where the organisation will need international talent and whether existing immigration programs are being used to their full potential.
And Soph?
I think, Charles, you cheated. 3 questions. It's a tough question in the context of, the last few years where we've had such a huge amount of significant reform in the space. So I'm going to limit my answer just to, the topics we've been discussing today in particular and the relevance there. And I guess if I was a director or a senior executive, in mind with what we've just been through, it would really be, what are the questions I need to be asking to make sure that I'm satisfying the due diligence obligations in relation to wage theft? And that might include what kind of audits are being undertaken by the company to ensure that, we are complying with our payroll obligations. What systems and processes do we have in place where errors are identified? What kind of reporting to the board is happening? If we're in a space of remediation, what are those remediation efforts looking like and expediting? So I think in the context of this compliance discussion and given those new laws, it's asking those tough questions.
Terrific. I think I'd add one more, which is really a hybrid of both, and it's, what information do we have in our systems that could inform our compliance kind of audits? Because I do feel that there are a lot of organisations that have many different systems that touch the people that are working within the organisations, whether they are employees, contractors, volunteers, etc. And just, what are we sitting on that we know we have that knowledge, and are our systems working together? So
I think I'd add to that. Do we have the right governance structure in place that can work together with that sort of those systems and processes to make sure we're on top of that compliance? Yeah.
Terrific. Well, thanks, Charles and Sophie, for joining me today. That brings this episode to a conclusion. We will be back with you shortly with another edition.